Today's date is August 5th, 2011. The time is now 8:44 p.m. Today's subject is hold on. Interest in land. From these are readings. This is chapter 16 readings from my business law book from Grand Canyon University. Kind of like my portfolio, digital portfolio. Here we go. Interest in land. Any contract that creates or transfers an interest in land is within the statute of frauds. The inclusion of real estate contracts in the statute of frauds reflects the values of an earlier agrarian society in which land was the primary basis of wealth. Our legal system historically has treated land as being more important than other forms of property. Courts have interpreted the land provision of the statute of frauds broadly to require written evidence of any transaction that will affect the ownership of an interest in land. Thus, a contract to sell or mortgage real estate must be evidenced by a writing, as must an option to purchase real estate or a contract to grant an easement or permit the mining and removal of minerals on lands. A lease is also a transfer of an interest in land, but most state statutes of frauds do not require leases to be in writing unless they are long-term leases, usually those for 1 year or more. On the other hand, a contract to erect a building or to insure a building would not be within the real estate provision of the statute of frauds because such contracts do not involve the transfer of interests in land. Exception: full performance by the vendor. An oral contract for the sale of land that has been completely performed by the vendor, seller, is taken out of the statute of frauds. That is enforceable without a writing. For example, Peterson and Lincoln entered into an oral contract for the sale of Peterson's farm at an agreed-on price, and Peterson, the vendor, derives a deed to the farm. 2. Lincoln. In this situation, the vendor has completely performed, and most states would treat the oral contract as being enforceable. Exception: past performance action in reliance by the vendee. When the vendee purchases of land does an act in clear reliance on an oral contract for the sale of land, and an equitable doctrine commonly known as the part performance doctrine permits the vendee to enforce the contract notwithstanding the fact that it was oral. The part performance doctrine is based on both evidentiary and reliance consideration. The doctrine recognizes that a person's conduct can speak louder than words and can indicate the existence of a contract almost as well as writing can. The past performance doctrine is also based on the desire to avoid the injustice that would otherwise result if the contract were repudiated after the vendee's reliance. Under section 129 of the Restatement Second of Contracts, a contract for the transfer of an interest in land can be enforced even without a writing if the person seeking enforcement has reasonably relied on the contract and on other parties' assent, has changed his position to such an extent that enforcement of the contract is the only way to prevent injustice. In other words, the vendee must have done some act in reliance on the contract, and the nature of the acts must be such that restitution, returning his money, would not be an adequate remedy. The part performance doctrine will not permit the vendee to collect damages for breach of contract, but it will permit him to obtain the equitable remedy of specific performance. A remedy whereby the court orders the breaching party to perform his contract. A vendee's reliance on an oral contract could be shown in many ways. Traditionally, many states have required that the vendee pay part of all the purchase price and either make substantial improvements on the property or take possession of it. For example, Contreras and Miller orally enter into a contract for the sale of Contreras land. If Miller pays Contreras a substantial part of the purchase price and either takes possession of the land or begins to make improvements on it, the contract would be enforceable without writing under the part performance doctrine. These are not the only sort of acts in reliance that would make an oral contract enforceable. However, under the Restatement Second approach, if the promise transfer land is clearly proven or is admitted by the breaching party, it is not necessary that the act of reliance include making payment, taking possession, or making improvements. It still is necessary, however, that the reliance be such that restitution would not be an adequate remedy. For this reason, a vendee's payment of the purchase price standing alone is usually not sufficient for the part performance doctrine. Contracts that cannot be performed within 1 year. A bilateral executory contract that cannot be performed within one year from the day on which it comes into existence is within the statute of frauds and must be evidenced by a writing. The apparent purpose of this provision is to guard against the risk of faulty or willfully inaccurate recollection of long-term contracts. Courts have tended to construe it very narrowly. One aspect of this narrow construction is that most states hold that a contract that has been fully performed by one of the parties is taken out of the statutes of frauds and is enforceable without a writing. For example, Nash enters into an oral contract to perform services for Thomas for 13 months. If Nash has already fully performed his part of the contract, Thomas will be required to pay him the contract price. In addition, this provision of the statute has been held to apply only when the terms of the contract make it impossible for the contract to be completed within 1 year. You will see an example of this principle in the following Scott T. versus St. Jude Medical SC case. If the contract is for an indefinite period of time, it is not within the statute of frauds. This is true even if in retrospect the contract was not completed within a year. Thus, Weinsberg agreement to work for Wolf for an indefinite period of time would not have to be evidenced by a writing. Even if Weinberg eventually worked for Wolf for many years, the mere fact that performance is unlikely to be completed in 1 year does not bring the contracts within statute of frauds. In most states, a contract for life is not within the statute of frauds because it is possible, since death is an uncertain event, for the contract to be performed within a year. In a few states, such as New York, contracts for life are within the statute of frauds. Computing time. In determining whether a contract is within 1 year provision, courts begin counting time on the day when the contract comes into existence. If under the terms of the contract it is possible to perform it within 1 year from this date, the contract does not fall within the statute of frauds and does not have to be in writing. If, however, the terms of the contract make it impossible to complete performance of the contract without breaching it within 1 year from the date on which the contract came into existence, the contract falls within the statute and must meet its requirements to be enforceable. Thus, if Hammer Company and McRae agree on August 1st, 2009 that McRae will work for Hammer Company for 1 year beginning October 1st, 2009. The terms of the contract dictate that it is not possible to complete performance until October 1st, 2010 because that is more than 1 year from the date on which the contract came into existence. The contract falls within the statute of frauds and must be evidenced by a writing to be enforceable. Shad T. versus St. Jude Medical S.C. S.C. Inc. S.C. Inc. Incorporated. 2007 United States District LEXIS 59586. United States District CT.D. Minnesota 2007. St. Jude is a large medical device manufacturer. In July 2001, Sharti began working as a product manager in St. Jude's cardiac rhythm management division. By all accounts, she performed well. Eventually, though, she became frustrated by sexual harassment and sexual discrimination within her division, so she applied for and obtained a position within another St. Jude division, the United States Sales Division, USD. Shati began working in USD as a field marketing manager in May 2004. Shortly after she started her new position, USD asked her and all of her other field marketing managers to sign a written contract containing non-solicitation and confidentiality provisions. In return for agreeing to these provisions, the field marketing managers who would otherwise be employees at will were given 1 year terms of employment. The contract required St. Jude to employ Shati for a minimum of 1 year, and it prohibited Shati from soliciting St. Jude's employees for 1 year after the termination of her employment with St. Jude. USD gave the employment agreement to Shati and asked her to sign it. The parties dispute whether Shati signed it. She alleged that she did sign it, but there is no proof that any representative of St. Jude signed the contract. Shati had conflicts with her supervisor in USD and began looking for another job. She told recruiters that she did not like her current position and wanted to pursue another opportunity before Shati could quit. Though she was fired, Shati sued St. Jude for breach of contract as well as other claims, and St. Jude moved for summary judgment of the breach of contract claim on the ground that it was barred by the statute of frauds. United States District Judge Schalitz A contract falls within the statute of frauds unless the contract by its terms is capable of being fully performed within 1 year. 1. Performance within 1 year. Shati argues that the statute of frauds is inapplicable because her contract with St. Jude was capable of being fully performed within 1 year. According to Shati, she could have quit her job 30 seconds after she agreed to the contract. That would have triggered the running of the 1 year non-solicitation commitment, and she could have fulfilled that commitment within 1 year of the date that she entered the contract. Shati's argument is unveiling. The test under the statute of frauds is whether the parties to a contract all parties can perform their obligation within 1 year. In any contract, something might arise within 1 year that excuses performance that obviously cannot be enough to defeat application of the statute of frauds, or no contract would ever be covered by the statute. For purposes of the statute of frauds, the question is not whether something might arise within 1 year that would excuse performance, but whether the parties can fully perform their obligations under the contract within 1 year if those obligations are not excused. The St. Jude Shati contract contains 2 commitments: a commitment by St. Jude to employ Shati for at least 1 year, and a commitment by Shati not to solicit St. Jude's employees for 1 year. After leaving the employ of St. Jude, the parties could not fully perform all other duties under the contract within 1 year. True, if Shati quit her job 30 seconds or 30 days after entering the contract, St. Jude would be excused from performing its obligations to employ Shati for a year. But St. Jude would not have performed its obligations. St. Jude needed 1 full year to perform its obligations under the employment provision, and Shati, of course, needed an additional year to perform her obligation under the non-solicitation provision. If the law were as Shati would have it, then no employment contract would ever fall within the statute of frauds, because an employee can always quit or become disabled or die. A few seconds after entering the contract, for example, an employee could allege that an employment contract for a term of 5 years was not within the statute of frauds because the employee could have quit the day after agreeing to the contract. Minnesota courts have consistently rejected such arguments. In some, the St. Jude Shati agreement was, by its terms, not to be performed within 1 year for the making thereof. Minnesota State Stat 513.01. St. Jude, the party charged with breach, did not sign the contract, and therefore, under the Minnesota statute of frauds, the contract is unenforceable at St. Jude's option. 2. Necessity of a signature. Shati argues that despite the fact that St. Jude did not sign the contract, St. Jude drafted the agreement, and that is sufficient to satisfy the statute of frauds. Shati relies most heavily on Beach versus Anderson, Minnesota CTAPP. 1988. In Beach, the parties entered into an oral contract that included a 6-year non-compete provision. The oral contract in Beach was transcribed by a court reporter. In addition, both parties in Beach explicitly assented to be bound by the contract, and their assent was transcribed by the court reporter. Disputes later arose between the parties, and one of the parties attempted to avoid the contract by arguing that it was subject to the statutes of frauds because of the 6-year non-compete provision, and that the statute had not been satisfied because the contract had never been reduced writing and signed. The Minnesota Court of Appeals agreed that the contract was within the statute of frauds, but held that the statute's requirements were met because not merely the terms of the contract, but the parties' assent to those terms had been transcribed. Beach is obviously distinguishable from the present case. Here, as was true in Beach, there is no real doubt about the terms of the contract. St. Jude asked Shati to sign the same form of contract that it provided to many other employees. But here, as was not true in Beach, there is substantial doubt about whether both parties assented to the contract. The court has a great deal of sympathy for Shati when there is no real doubt about the terms of the proposed St. Jude Shati contract, and no real doubt about that St. Jude would have signed the contract if it had timely received a signed copy from Shati. It does seem that dismissing Shati's breach of contract claim exalts form over substance, but the statute of fraud is by its nature a formalistic statute. It provides that in some circumstances form is such as important as a substance. This is a decision of the Minnesota legislature, and this court is obligated to honor that decision. When the Minnesota statute of frauds clearly requires that the St. Jude Shati contract be reduced to writing and signed by the parties against whom enforcement is sought, the court will not expand Beach to eliminate the need for any objective evidence of assent. Summary judgment granted in favor of St. Jude. That is the end of this little section. Again, this is chapter 16.